Thank you very much. I think you've expressed your position very well. Next, we can move to Lynn Gehl to give our final panelists a chance to settle down. And please, I don't want to take your time. Go ahead, Lynn.
Hi, thank you for inviting me here today. Welcome to Algonquin Anishinaabe territory. This is my home territory, and so I'm happy to be here. I've been working on the issue of sex discrimination in the Indian Act for more than 32 years. It was in 1945 when my great-grandmother, Annie Maness, was informed by Indian agent H.P. Ruddy that she became a white woman when she married Joseph Gagne, who was only Indian through his mother, Angeline Jocko. That was 72 years ago, yet the sex discrimination that denied my great-grandmother continues to deny my nieces and nephews today. When the Indian Act was amended in '85 to bring it in line with the Charter of Rights, the very provisions that protected children of unknown and unstated paternity were suspiciously removed from the Indian Act, and it became silent on the matter. Subsequently, INAC then began their process of discriminating against these children at the departmental level through a proof of paternity policy that assumed all unknown and unstated paternity situations were non-Indian men. In their process of harming Indigenous mothers and children through this policy, INAC claimed they lacked the ability of reason and moral judgment. In INAC's defense, the Department of Justice also argued Indigenous women would take advantage of Indian status registration rights if there was a gap in the policy. It took me 22 years to move through Canada's court system. In this process, I was against many barriers, such as a mother who didn't want me to look critically at issues of paternity, a lack of funds to move the process through the court system in a good way, INAC's deep, deep pockets of money gained through unilateral access to Indigenous land and resources, and INAC's absolute failure to disclose evidence so it could be properly adjudicated as per the rule of law. Regardless of the misery imposed, this past April, the Ontario Court of Appeal judgment came through and it was determined I won. In short, the court determined that INAC's proof of paternity policy that assumed all unknown and unstated paternity situations were non-Indian was unreasonable. The process of defending against my quest for Indian status cost Canada more than $750,000. Yet I was told I was the mischievous one. It is now clear to me that Canada is hell-bent on eliminating status Indians and the associated treaty rights through the methods of sex discrimination and off the backs of Indigenous women and their descendants. While lawyers view the outcome of my court case as a victory, I struggle with this joy. I'm happy that the court struck down INAC's proof of paternity policy, and I'm happy that the clauses that my legal representatives, Emily LaHaye and Mary Eberts, put forward, and the evolution of the clauses established through consultation with Minister Bennett's office. One of the clauses directs INAC to accept circumstantial evidence, and the other one directs INAC to not to assume non-Indian paternity in situations of rape. That said, I'm not happy that the judges said I was only entitled to 6-2 status. This is wrong. I was born pre-1985, and therefore I should be entitled to 6-1A status. My great-grandmother's brother's descendants are all entitled to be registered under 6-1A. With this so-called court remedy of granting me 6-2 status, I am only entitled to being less than because of my matrilineal ancestry. Indigenous women have worked hard to resolve the sex discrimination. Mary Tuax Early, Jeanette Corbier-Laval, Yvonne Bedard, Sandra Lovelace, Sharon MacGyver. Together, we took what we thought was the right path. The Liberal government came into power on the platform of reconciliation and respecting the nation-to-nation relationship. If this government moves forward with the 6-1A all-the-way remedy, as I hope, a remedy that addresses all the sex discrimination in the Indian Act, Prime Minister Justin Trudeau and Minister Carolyn Bennett and the rest of Canada will truly have something to celebrate. Otherwise, Canada will remain stained. Again, it took me 22 years to move through Canada's court system where, in the end, the so-called remedy offered is nothing but a new form of sex discrimination. A new form of sex discrimination. This is not fair and is out of line with the Charter, and Canada can do better than this. So the first thing I really want to clarify is the discussion of the need to respect the nation-to-nation consultations. They will never occur if the matrilineal descendants are missing from First Nation bands. Never. So right there, that's not happening. And so while INEC claims they cannot move forward with the 6-1A all the way remedy and thus remove all the sex discrimination because of the claim need to consult on a nation-to-nation basis, at the same time, INEC prevents First Nations from welcoming their members through imposed fiscal restraints that are not rooted in genuinely valuing what is nation to nation, such as sharing the land and resources in an equal way and in a way that Indigenous nations are able to embrace matrilineal descendants. On the one hand, Canada is saying it cannot resolve all the sex discrimination as it must respect the nation-to-nation relationship. Yet on the other hand, it doesn't really want the Indigenous nations to enter into what are genuine nation-to-nation discussions. The second thing that I'd really like to add clarity to that is that, yes, it is true that First Nations, such as my grandmother's band, conflate Indian status and band membership. This practice is being argued by an INAC as their excuse not to resolve all the sex discrimination, as there's the need for First Nations to be consulted. We need to keep in mind that First Nation band memberships are within the jurisdiction of the First Nations, not INAC. And that said, regardless, the goal here that we're discussing today is the need to resolve sex discrimination in law, not First Nation band membership codes. Third, Canada's failure to resolve the matrilineal descent sex discrimination actually establishes a colonial and patriarchal foundation in land claim and self-government process, in that the descendants of Indigenous women are marginalized and thus vulnerable in the process. Genuinely respecting the nation-to-nation relationship would abolish the sex discrimination inherent in the 6-1A and the 6-1C hierarchy. Fourth, in fact, contrary to the claim that there is a need to respect the nation-to-nation relationship, Canada is not doing that at all. In the Algonquin land claim and self-government process, we're only being offered 1.3% of our land and a $300 million buyout. So that's not nation-to-nation. There's so much wrong with that. And fifth, the thing that I really want, the fifth thing I want to speak to is the argument that it would be irresponsible for Canada to implement the 6-1A all-the-way remedy without further analysis. It's my position that the claimed place of potential irresponsibility is actually an excuse that has been carefully constructed through decades of intentional and strategic deception and maneuvering rooted in the need for Canada to eliminate Indians. The Canadian government has been completely aware of Indigenous efforts to remove all the sex discrimination. This is not new, not at all. Canada has had decades of time, as well as the deep pockets of money required to accommodate the research needed to draft legislation that would remove all the sex discrimination and bring about charter compliance. Instead, what Canada has done is place its time, dollars, and efforts into crafting legislative amendments that ignores, confounds, disguises, and for that matter, crafts silent forms of sex discrimination, such as what we've learned from Gehl versus Canada. In this process, INEC has in fact crafted new forms of sex discrimination versus ensure the Indian Act is charter compliant. It is my position that Canada's claimed position, it would be irresponsible to move forward without further analysis, is more about disrespecting what is genuinely a nation-to-nation relationship, and it is the complete manipulation of Indigenous women's agency, Indigenous women who are already burdened. I ask members of the committee to support the amended version of Bill S-3. It is crucial to upholding the human rights of Indigenous women and their descendants, and to finally putting an end, putting Indian women and their descendants born prior to 1985 on the same footing as Indian men and their descendants born prior to 1985. Please stand with Indigenous women's call for charter compliance and equality. Miigwech.
Thank you very much.